All right, so guys, you had a big Supreme Court victory. A lot of people were getting a ton of questions from people over what this means. That's really the purpose of what we're going to go over today. So I'm here with Patrick Wright, Vice President of Legal Affairs at the Mackinac Center, Mike Van Beek, who's the Director of Research, who had done a study looking back on a lot of the emergency orders over the years. You guys are the people to answer these questions, so let's get going. First of all, Patrick, what did the court decide here?
Well, 7-0, they decided that the governor acted improperly in trying to extend the emergency past April 30th when the legislature said that they wanted to get back involved and to take over and to be involved in the process of deciding what needed to occur. 4-3, the Supreme Court said that there was one particular law, a 1945 law, that was unconstitutional that the governor had been using as part of her claim of having executive sole power to make any of these decisions.
Would it be fair to say, so that the court ruled unanimously that the governor was violating the law, and more narrowly that one of the laws that she was using is unconstitutional?
Yeah, I think that's fair. It was 7-0 in one and 4-3 in the other, yes.
All right, so what, for both you guys, so what are the immediate effects on people? Can we burn our masks? What's going on here going forward?
Burning masks, I don't think, everybody's going to have to make individual determinations. There'll also be some legal determinations that come into play. What are the counties going to do? What has the administrative agencies within the state said? What other legal methods can the governor influence our behavior by? But even if there's nothing, then obviously all the businesses are going to want to make individual determinations as to what's best for their customers and what's best for their business. So I don't think that we're in a situation where masks are going to be a thing entirely of the past. We'll see. But we do know a lot more about the epidemiology than we did 6 months ago. We started this in March 10th. We were afraid that we might have 200,000 deaths. We've had 200 nationally, 6,700 here in Michigan. It's still an extremely important matter. Still very dangerous to certain populations, but we know a lot more, and hopefully we'll use that knowledge going forward to make the best public policy to be as safe as we can possible without doing any kind of collateral damage to the economy or to other healthcare concerns.
Yeah, one of the things that was most confusing about the governor's position to take sort of unilateral control over the pandemic response was the state has plans in place for what to do when pandemics strike. So the Michigan Department of Health and Human Services, they're empowered to issue epidemic orders that can prohibit people from gathering, and they have other powers. Local health departments have similar powers. So basically, what is going to happen now is that the governor's attempt to take this on all by herself is going to come to an end, and we're going to have the normal processes in place and that we have in state law. We're going to play those out, and those are going to vary, county to county, business to business even. Private organizations have the ability to require people to wear masks or require people to do certain things to participate in their activities. Little league baseball or a soccer club or something like that, they could require participants to do these things. So, but that will be based on local decisions and private individuals negotiating those with each other. So
it might make more sense instead of having one person trying to dictate and figure out exactly what 10 million people need, if you have people that are in the localities. This is a reason why we have 110 representatives, 38 state senators. It's also a reason why we have all of our county and local officials. So, if you have a hot spot, you might have a different situation going on than in other portions of the state. Detroit is not the same as the UP, is not the same as mid-Michigan, and we need to be able to take some of these regional differences into account in deciding what's proper at any particular time.
So in the governor's executive orders in the past, she would issue some under this 1976 law that the court agreed that the legislature would have to extend that. She issued some over the 1945 law that has been declared unconstitutional, and she issued some through the health director, the state health director. Is it possible that the governor's just going to reissue these under the health director, say, nope, I'm going to reissue all the EOs the same way, get around the legislature that way? Is that possible? Is that legal? What are your thoughts on her doing that?
Well, it's. I mean, she's already indicated that she would explore that, and the director of the health department has already issued emergency orders that reinforce hers, the executive orders. So it seems likely that they would attempt to do that. Whether or not that's legal and how that all works is no one's attempted to do it before, as far as I know. So
that question came up at oral argument in the before the Michigan Supreme Court, and here's why it's probably not going to entirely work, and that is the reason why the court struck down as unconstitutional the 1945 Act is it gave too much power, unlimited, to the governor. What powers exist under the health statutes are narrower, so it is extremely unlikely that the governor would be able to just by administrative rule, reinstitute all of her executive orders. Some of them are just going to be outside of the scope of powers of what's been given to various officials. So will some of them come back? Obviously they will. Some of them might come back locality by locality, maybe a local official will decide to do them. So there's going to be a lot of stuff still to be figured out, but the governor will not be able to, just by doing a different switch and taking a different process, be able to get back everything that she had been working with.
And it's also important to remember there's other state departments that could issue orders or use the same protocol that the governor was mandating. MIOSHA, for instance, has the ability to issue emergency rules, so they could potentially require businesses to do all the same things that the governor was requiring them to do, and then enforce all of those and continue to fine businesses that they find in violation of those. I don't know if they'll do that, but there's certainly room in state law to suggest that they might have the power to do that.
And the lawyer in me just wants to fight the word everything. The governor will have the power to do many of the things that she had done before, but it's most likely that she will not be able to do everything. So we're going to see a narrowing of through the administrative rules process of what she had through the executive orders. Now, what she can do with the legislature, should they come to an accommodation and reach legislation, obviously they can do almost everything that the governor had been trying to do through executive orders. So it'll be interesting to see how those two entities work together. They work together well with the school reopening bill. They've worked together well in doing a budget. So despite the fact that we're in a highly partisan time, heading into a very important election, and that there's been some differences of opinion as to the right courses, I do expect that they'll be able to work together and reach some compromises on where we go from here.
Yeah, the governor came out right after the decision, and she said a couple of things. One, she said none of this goes into effect for 21 days. So I'd like to take your thoughts on that. And then the second thing that she said was, this makes Michigan alone a state without an emergency, portraying this as we're the ones that are really out there on a limb and we're unique by limiting the governor's power. How do you take those 2 points?
Well, the 21 days is being debated. It's largely going to become academic, because the AG has already said that she's not going to criminally enforce this. No prosecutor is going to enforce this. No sheriff is going to arrest anybody. There is this, everybody has seen what the Supreme Court does. We're not operating in a vacuum. So it is a lot of ado about nothing, quite frankly. As to the second point, I'm sorry, Jared, I forgot the second question.
Well, that was about what other is Michigan truly unique in not having an emergency compared to other states, and there's some truth to that. All the other states have declared.
However.
Yeah, all the other states have declared emergencies, but the important difference with that, of course, is that the vast majority of other states have declared emergencies using public health codes that really are there so that they can so that they can accept federal funding, federal emergency funding. Michigan was the real outlier in that our governor was using a law meant for dealing with riots to say she could command the entire response to COVID forever, however long she wanted. So we were really the outlier. Now it is true we're not going to have a declared emergency, but that's because I don't think the legislature is going to give the governor power anymore because she's demonstrated a willingness to abuse it.
So the other states that had the emergencies had to do it through the legislature.
Yeah, exactly. I mean, they're going to have the status that we have now, which is their governor and legislatures had to work together to craft policy to deal with COVID.
They had worked through statutes that were legal statutes. Ours was allowed as much power as almost the legislature had and gave it to the governor for unlimited time, and the Supreme Court said that that's just too much. So that's one of the ways that Michigan was an outlier. And again, in Wisconsin for a while, they didn't have any executive orders. They've tried to declare new emergencies. In Michigan, you still could declare an emergency. If we had a gigantic second wave and it hit, the 1976 law is still legal and could be used if the necessity required it. So the governor is not without emergency powers. What has happened is we have gone from a situation where it was an emergency to where it's just an extremely important matter. Again, 200,000 deaths nationally, 6,700 here in the state of Michigan. We're by no means out of the woods yet, and it's something that requires a lot of attention both from the governor and the legislature. But it will not be something where the governor can unilaterally do what she wants, when she wants, how she wants, for as long as she wants.
Really, a lot of the questions that we're getting here is, what does this mean for my local schools, my kids going to school, and what does it mean for my business? Can you answer those questions in the immediate term or maybe in the longer term?
Individually, it will depend on your local county health department. It might depend on the state health department. It might depend on your local school district. It might, for your business, it might depend on what MIOSHA comes up with. So a lot of it is still up in the air. But I think throughout this entire course of dealing with COVID, sort of an underlying truth about how people have reacted is that individuals make these decisions for themselves about what they should do, what they feel like they're comfortable with, and the risks they want to take. And they've been doing that all along. So I think they'll continue to do that, and we'll just continue to have to negotiate these different instances.
I'd bifurcate my answers. The school reopening was done through legislation, so I don't think we're going to see a tremendous change. I think we're about a month into the school year. I think that most people and most institutions are fairly comfortable with where they are at this point. So I don't think that there's anything about this decision that's going to cause a radical change.
The legislature largely left it up to local district for their plans. We did see that one of the executive orders was that all children in school must wear masks, which would be one that got struck down.
Right. So all executive orders for certain after April 30th, and there's a certain argument to be made that anything that dealt with before April 30th, there's no longer an emergency, so that those are probably ineffective too at this point. Right. So, maybe it'll end up being a district by district on the mask question. What I was talking about was as far as going to school versus doing remote learning, things of that nature. For the businesses, I think you're going to have a little bit more have to react to multiple sources, be it county, be it administrative, be it legislation. You used to be, to find out what the law was today, you had to hop online and see what the governor had done last night as far as executive orders. She was averaging about one a day. And there will now be undoubtedly some places that try and fill those gaps. So I do expect that people that carry the last name of JD will continue to be employed. And we'll see what occurs going from here.
So people obviously have tons of opinions on how serious COVID is, how to respond to it. We have different thoughts on that, even internally as a staff. But obviously, Patrick, you were the attorney. We filed the case. Why should everybody like how this ended up? Can you make a case for that?
They should like how this ended up because we reinstated the system of government that we've had for hundreds of years in the country and for 183 here in Michigan. We've done this through 4 constitutional conventions. And we have to remember that the United States Constitution and its separations of powers was set up in a crisis. This is supposed to be the kind of government and the kind of methodology that's supposed to be able to handle these sorts of things. What separations of powers does is it allows more people into the decision-making process. And so we've been talking a little bit about how Michigan, with 10 million people, with 540 school districts, 83 counties, 276 cities, it's not one homogeneous place. There's a lot of things that go into each individual determination of what needs to be done. Having a legislative process allows those people to go back to their districts, to bring their ideas, bring their concerns, expertise, and everything else to Lansing, and where we can make the best policy, weighing both the costs and the benefits, not just looking at this from one perspective. And so that's why this is a great ruling, and it's why everybody should be happy.
And of course, if they don't like it, we have an upcoming election, so they can vote or not vote for their representatives. Last question, there was a legislative proposal, citizens initiative, that people gather signatures to get rid of the 1945 law. Is that still relevant?
Yes, it is. What I believe is that is going to continue going forward for the concern that perhaps maybe the membership of the court will change. Justice Markman, who was one of the 4 people who voted that the 1945 law was unconstitutional, cannot run for re-election, and so will be replaced this year. So I think that there is some who are concerned that they don't want any future governor or any future court to be tempted to look at that law and bring it back to life. And so I do believe that initiative is going to go forward from here.
That's interesting because that law's been on the books since 1945. But what's different now is we've had a governor who tried to use it in an entirely new way. And that's, exemplified the real danger with this law. So it's still a good idea to get this law off the books because it is a dangerous one. And Governor Whitmer has demonstrated a willingness to abuse it. And now the Supreme Court has said it's unconstitutional.
All right. Thank you, gentlemen.